17. Same explanation of Equity Rule 90 by the Supreme Court. Between March 1822, the date of the promulgation of the first equity rules, and March 1842, the date of the promulgation of Equity Rule 90, there were many and material changes in the procedure of the High Court of Chancery in England, and it therefore has become important to know. I7 Wheat v. 2 Story v. Livingstone, 13 Pet 359. 18 Federal Equity Procedure. 18. To which one of these dates we are to look, in order to determine the exact limitations and modification of the procedure adopted by Rule 90. In this we are not left without a guide. The language of the rule is, the present practice of the High Court of Chancery in England, that is, the practice as it existed on March 2, 1842, WHJ, N-Rul 1 90 was adopted. To a case, decided by the Supreme Court in 1884, there is a note by the court explanatory of Rule 90. The note is as follows. Reference is made to the first edition of Daniel, published 1837, as being, with the second edition of Smith's Practice, published in the same year, the most authoritative of English Chancery practice in use in March 1842, when our equity rules were adopted. Supplemented by the general orders made by Lords Cattenham and Langdale in August 1841, many of which were closely copied in our rules. They exhibit that present practice of the High Court of Chancery in England, which by our 90th rule, was accepted as the standard of equity practice in cases where the rules prescribed by this court or the circuit court do not apply. The second edition of Mr. Daniel's work, published by Mr. Hedham in 1846, was much modified by the extensive changes introduced by the English Orders of May 8, 1845, and the third edition by the still more radical changes introduced by the Orders of April, 1850, the Statute of 15 and 16 Vt. Chapter 86, and the general orders afterwards made under the authority of that statute. Of course the subsequent editions of Daniel are still further removed from the standard adopted by this court in 1842, but as they contain a view of the later decisions bearing upon so much of the old system as remains, they have on that account a value of their own, provided one is not misled by the new portions. 118. Same. Orders of the High Court of Chancery in England from the above interpretation of the 90th Equity Rule by the Supreme Court, it would seem, that the general orders of the High Court of Chancery in England, which were in force on March 2, 1842, are, when they may reasonably be applied consistently with the local circumstances and local conveniences of the district, where the court is held, in cases not covered by our own rules, an essential element of the system. L. Thompson v. Worcester, 114 U.S. 104, 112. 19. 20.J System and Sources of Equity Procedure 19. -0F Equity Procedure adopted for the Circuit Courts of the United States. These orders furnish clear, decisive and salutary rules to guide the profession upon a large number of matters of procedure, and are, in many instances, an embodiment of the results of the English Chancery decisions. 19. Circuit courts may make equity rules. The second section of the Act of May 8, 1792, authorized the circuit courts to regulate their proceedings in suits in equity, which statute was in this, as in other respects, several times amended, and, with its amendments, was revised and carried into the revised statutes in the following form: the several circuit and district courts N.I.A. from time to time, and in any manner not inconsistent with any law of the United States, or with any rule prescribed by the Supreme Court under the preceding section, Sections 917, make rules and orders directing the returning of writs and processes, the filing of pleadings, the taking of rules, the entering and making up of judgments by default and other matters. Invocation, and otherwise regulate their own practice as may be necessary or convenient for the advancement of justice and the prevention of delays in proceedings. 1. And it is provided by an equity rule, that the circuit courts, both judges concurring therein, may make any other, and further rules and regulations for the practice, proceedings, and process, mesne and final, in their respective districts, not inconsistent with the rules hereby prescribed, in their discretion, and from time to time alter and amend the same. to the circuit courts -0 and not make any rule in equity, which is in conflict with any rule prescribed by the Supreme Court, or inconsistent with any law of the United States. 3 courts may change their procedure without promulgating any formal written rules. Uniform modes of procedure continued for a series of years constitute rules of court equally with those established by formal order for 20. Equity procedure same in all the states. The forms of mess and process and the forms and modes of proceedings in suits and equity in the circuit courts of the United States are 1 USRS, 2nd 918. 2 Equity Rule 89. Astory v. Livingston, 13 Pet 359. Bank v. White, 8 Pet 262. Bean v. Heath, 12 How 168. USRS, 6. 913, 917 and 918. 4 Duncan v. United States, 7 Pet. 435. 20 Federal Equity Procedure. 21. The same in all the states of the Union, and are not in any manner regulated or controlled by the equity procedure of the states. It has long been the settled doctrine of the Supreme Court of the United States that the remedies in equity in the circuit courts of the United States are to be administered, not according to state procedure, but according to the procedure of courts of equity in the parent country, as contradistinguished from the courts of law, subject, of course, to the provisions of the acts of Congress, and to such alterations and rules as, in the exercise of the powers delegated in those acts, the courts of the United States may from time to time prescribe. 21. Authorities upon equity procedure in the circuit courts. The federal statutes and equity rules are absolutely controlling upon all points covered by them, and the decisions of the Supreme Court, in construing the rules and statutes, and in ascertaining, declaring, and applying the principles, rules, usages, and forms of the equity procedure of the English High Court of Chancery, are conclusive upon all the courts of the United States. But as questions of procedure are first raised in the circuit courts, and only a small proportion of those questions are ever carried up to the 3 appellate courts for revision, the profession must resort chiefly to the reports of the decisions of the circuit courts and the Circuit Court of Appeals for the learning upon equity procedure. The first edition of Daniel's Chancery Practice, and the second edition of Smith's Chancery Practice both have been specially mentioned by the Supreme Court to as authority in the courts of the United States touching matters of equity procedure. Of course, much of the matter in these books is obsolete, much is inapplicable to local conditions and the constitution of our courts, and much of it has been superseded by our equity rules and the English orders in force at the time of their adoption, and which constitute a part of the English system of equity procedure, upon which, as a foundation, our equity system has been established. 1 Robinson v. Campbell, 3 Wheat, 212, United States v. Howland, for Wheat 115, Neves v. Scott, 13 Howe, 27, Boyle v. Zachary, 6 Pet 658. Story v. Livingston, 13 Pet 36. Poultney v. City of Lafayette, 12 Pet 474. Bean v. Heath, 12 How 168. 2114 US 112. 22, 23. System and Sour CSOF Equity Procedure 21. 22. Same. Chancellor Kent's opinions in an address upon the use and value of authorities before the students of the Law Department of the University of Pennsylvania on October 1, 1888, by Hon. Samuel F. Miller, then the Senior Associate Justice of the Supreme Court of the United States, b. said, so any one of the cases decided by Chancellor Kenton, the 7 volumes of Johnson's Chancery Reports will stand, so far as it applies, as almost conclusive of the principles of equity jurisprudence in the High Court of Chancery of England. 1. What Justice Miller has said of the opinions of Chancellor Kent in regard to the principles of equity jurisprudence is equally true in regard to the principles, rules, usages, and underscore forms of the equity procedure of the High Court of Chancery of England. The old New York Chancery system, like the equity system of the United States courts, was built upon the English Chancery system, and the general frame and features of a suit in the New York Chancery courts, and many of its minor incidents, under the Chancery rules of that state, were substantially the same as in a suit in equity in the circuit courts of the United States, and not only the opinions of Chancellor Kent, but also the opinions of Chancellor Woolworth, and, indeed, the whole of the New York Chancery reports, when used with discriminating care and a due regard to the differences between the New York Chancery rules and the United States equity rules, are of very great utility and value upon questions of federal equity procedure and pleading. 23. Ancient English equity pleading. The Great System 9F English equity pleading and procedure, like all administrative systems, had its crude beginning, followed by growth, development and maturity, and in this system as at the present time, administered in the circuit courts of the United States, we behold the splendid evolution of the law. In the common law courts, personal actions were commenced by original writ, which was a mandatory letter from the king in Chancery, sealed with the Great Seal, and by the possession of which, when served and returned, the court was seized of the cause, and had jurisdiction to entertain it too. But when the equitable jurisdiction arose, and assumed definite form, and the Court of Laymican Law Review, Volume 23, Number 2, p. 168, 21ted, Prac 93-99. 22. Federal Equity Procedure. 23. Chancery became established as a separate court for the administration of this extraordinary jurisdiction. Suits were commenced there by the filing of a petition or bill. At first the bill was very brief and simple. It contained a concise and simple statement of the facts of the plaintiff's case, without any attempt to anticipate the defense of the defendant, and concluded with a prayer for a subpoena, if the chancellor was of opinion that the bill presented a case calling for the interposition of the court. The subpoena issued, requiring the defendant to appear in person in chancery on a day named, to answer to what should then and there be objected to him. It seems that from the very first, as one of the means to relief, discovery by the defendant was compelled. When the defendant appeared, he was examined personally before the chancellor, and at the same time, made bis defense to the suit by plea or answer, which was a brief statement of the facts relied on by him to bar or defeat the relief sought by the bill. The English lawyers attempted to introduce into the Court of Chancery the common law system of pleading with all its technical rules. That system sought to attain three results, namely, 1. The production of a single certain material issue of fact, 2. The complete separation of issues of fact from issues of law, and 3. The trial of all issues of fact by a jury, and the trial of issues of law by the presiding judge. 1. It was, by its essential constitution, unsuited as a procedure to the administration of the equitable jurisdiction in Chancery, where all issues both of fact and of law were decided by the chancellor, and justice was administered upon broad and liberal principles, unrestrained by the technical rules of the common law. The attempt to introduce the common law pleadings was resisted by the chancellors with a measure of success, but there was, nevertheless, established and 4 years maintained in the Court of Chancery a system of special pleading analogous to the common law pleading, but less technical and rigid. This ancient system of special equity pleading, covering the entire range, and bearing the very names of common law allegations from plea to subutter, was borrowed from the latter system, but being found unsuited to the purpose was abandoned. It is set forth by the writers on the subject as follows. A replication is the plaint. L. Stevens Place, 9th edition, 127, 135, 136, 137. 24. System and sources of equity procedure. 23. If's answer or reply to the defendant's plea or answer. Formally, if the defendant, by this plea or answer, offered new matter, the plaintiff replied specially to the new matter. Otherwise the replication was merely a general denial of the truth of the plea or answer, and pf the sufficiency of the matter alleged in it to bar the plaintiff's suit, and an assertion of the truth and sufficiency of the bill. The consequence of a special application was a rejoinder, by which the defendant asserted the truth and sufficiency of bis answer, and traversed every material part of the replication. If the parties were not then at issue by reason of some northeast matter disclosed in the rejoinder which required an answer, the plaintiff might subjoin to the rejoinder, and the defendant might, in like manner, abut to the surrejoinder. Another statement of the ancient pleading is as follows: the bills were formerly of a very simple character, not taking any notice of the real, or supposed defence which would be set up by the defendant. The defence came out upon a plea, and the replication stated the matter in avoidance of the plea, and then the rejoinder denied the matter in the replication, and the parties were then at issue. When, for example, according to the old practice, a plaintiff by his bill stated a case for relief, if there had been a former decree on the merits, which he sought to set aside on account of fraud in obtaining the decree, the bill did not in any manner whatsoever allude to the decree. It was left to the defendant to plead the decker as a defence, barring the plaintiff's right. And the plaintiff then by his replication would reply that the decree had been obtained by fraud, by which the plaintiff would admit that the decree was a bar, if not capable of impeachment on the ground of fraud. The defendant would by his rejoinder avoid or deny point the charge of fraud, and sustain the decree, and the issue would be simply on the fact of fraud. The pleadings in ancient times frequently proceeded to a surrejoinder and rebuttal. 1. 24. The matured English equity pleading, the inconvenience, delay and unnecessary length of pleading, arising from the various allegations on each side, in the system. 11 Spence, 367-377. 2 Daniel, 387, Mitford, 382, Stories Ec. Place, Sex 676, 677, 878. 24 Federal Equity Procedure. 24. Of special pleading, that anciently obtained in the Court of Chancery, occasioned an alteration in the practice. Special replications, with all their consequences, were abandoned, and have long been disused, and, according to the matured system of equity pleading which followed, as a logical development upon the abandonment of the ancient system, the plaintiff is to be relieved according to the form of the bill, whatever new matters may have been introduced by the defendant's plea or answer. But if the plaintiff conceives, from any matter offered by defendant's plea or answer, that his bill is not properly adapted to this case, he may obtain leave to amend the bill, and suit it to this cause, as he shall be advised. To this amended bill the defendant may make such defence as he shall think proper, whether required by the plaintiff to answer or not. 1. An equity rule provides that no special replication to any answer shall be filed. But if any matter alleged in the answer shall make it necessary for the plaintiff to amend his bill, he may have leave to amend the same, with or without the payment of costs, as the court or a judge thereof may, in his discretion, direct. 2. And it is provided by another equity rule that, in every case, where an amendment shall be made after answer filed, the defendant shall put in a new or supplemental answer on or before the next succeeding rule day after that on which the amendment or bill is filed, unless the time is enlarged, or otherwise ordered by a judge of the court. 3. The principles embodied in these rules were a part of the English equity pleading and procedure long before the promulgation of our equity rules. The pleadings in equity in the matured system consist of the bill, answer or plea, and the general replication, and are as to bills only. The general replication introduces no new matter, but simply puts in issue the defendant's plea or answer, and closes the pleadings for the proofs for the $. Of special replications and other special pleadings resulted, necessarily, in great and material changes in the frame and structure of bills and answers. Under his change the bill performs the double function of a bill. 12 Daniel, 388, Mitford, 382, 383, Story, Ec. Place, Seconds 378. 2 Equity Rule 45. Equity. Rule 46. 4 Story, Ec. Place, Seconds 878. Humes v. Scruggs, 94 U.S. 22, Cavender v. Cavender, 114 U.S. 464. 24. System and sources of equity procedure 25. And of a replication, and the answer of defendant performs the double function of an answer and a rejoinder. The bill, instead of relying solely on the matter constituting the plaintiff's original case, proceeds to anticipate the defense, and charges facts to avoid that defense. and requires a discovery as to the matter charged. The change in the structure of the bill required a corresponding change in the defense of defendant 1 instead of the special pleadings, as formerly we have, in the matured system, bills and amended bills, answers and amended or supplemental answers. An amended bill, by setting up by IA of pretense the new matter brought forward in defendant's answer, and avoiding it by counter-averments, is often made to perform the functions of a special replication under the \L old system, and an amended or supplemental answer is made to perform the functions of a rejoinder, as that pleading was formerly used. 3. And though the original bill or answer, and the amendment pointents thereto, are separately engrossed, yet the original pleading, and its amendments, or supplement in the case of an answer, constitute but one pleading or record for I story, ec. Place, second 678. 2 story, ec. Place, seconds 8 feet 78, Storms v. Storms, 1 EDW. Chapter 358, Marstal Levy. McLean, 7 Cranch, 156, Wilson v. Stolle, 4 McLean, 275, Vadtier v. Hint, 7 Peters, 252, Beard v. Vattier, 9 Peters, 405, Terben. Ham, 5 How 233, DuPont v. Mussey, 4 Wash 128. 3 Equity Rule 46.2 Daniel, 335, 33 Ann, 41 Daniel, 509. 2 Daniel, 336, Story, ec. Place, seconds 868, French v. Stewart, 22 Wall, 89 US, 247. Chapter 3. Interlocutory procedure before the clerk at rules, and before the judges at chambers. 25. Circuit courts as courts of equity always open. 26. The clerk to hold monthly rules and grant certain orders and proceedings. 27. Orders by the judges at chambers and at rules. 28. The order book. 29. Same notice. 30. Policy and method of the interlocutory procedure. 81. Same when pleadings are to be filed. 32. Same when exceptions to pleadings for scandal and impertinence are to be filed. 33. Same when exceptions to answers for insufficiency are to be filed. 34. Default of parties in interlocutory procedure. 35. Interlocutory procedure upon removal. 36. Purposes of the first, second, and third chapters. 25. Circuit courts as courts of equity always open. The circuit courts, as courts of equity, shall be deemed always open for the purpose of filing bills, answers and other pleadings, for issuing and returning mezzanine final process and commissions, and for making and directing all interlocutory motions, orders, rules and other proceedings preparatory to hearing of all causes upon their merits. Interlocutory orders and proceedings in suits in equity are of 2 kinds, namely, 1. Those which are grantable of course, and may be obtained by suitors without the allowance or order of the court or any judge thereof, and 2. Those which are special, and not grantable of course, and can be obtained by suitors only upon the allowance of the court or a judge thereof. And all interlocutory motions, orders, rules, and proceedings are intended, by the rules, to prepare causes for hearing upon their merits, and should be adapted to that end. 1. The interlocutory procedure, provided for and established by the equity point rules, was framed with a view of speeding causes to a final hearing, and is admirably adapted to that end, and this system of procedure, when viewed with reference to the purpose had in view by those eminent and learned jurists. 1 USRS, second 638, Equity Rules 1, B, 5. 26. J. Inter, T. Locutory Procedure. 27. Through whose labor and care it has been established and perfected, must be regarded as the very consummation of human skill and learning, and it is much to be regretted that these rules are so often neglected in the conduct of causes, for the greatest complicity, that arise in equity suits are usually in the procedure preparatory to the hearing on the merits. 26. The clerk to hold monthly rules and grant certain orders and proceedings. The clerk's office shall be open and the clerk shall be in attendance therein on the first Monday in every month for the purpose of receiving, entering, entertaining, and disposing of all motions, rules, orders and other proceedings which are grantable of course and applied for, or had by the parties or their solicitors. In all causes pending in equity, in pursuance of the equity rules prescribed by the Supreme Court, one parties to suits are, by virtue of the mere force and authority of the equity rules, entitled, as a matter of absolute right, to all orders and proceedings grantable of course, and the clerk is required by the rules, to grant and enter them, on rule days or in vacation, according as the rules may direct, without any notice to the adverse party, or any order of the court or a judge, thereof. To all motions and applications in the clerk's office for the issuing of messen process and final process to enforce and execute decrees, for filing bills, answers, pleas, demurrers and other pleadings, for making amendments to bills and answers, for taking bills pro confesso, for filing exceptions, and for other proceedings in the clerk's office which do not, by the equity rules, require any allowance or order of the court or of any judge thereof, shall be deemed motions and applications grantable of course by the clerk of the court. 3 following are some of the motions and applications tabled by the clerk, namely, if defendant make default in filing his plea, demurrer or answer, the clerk may make and enter an order, that the bill be taken pro confesso. For an order to amend plaintiff's bill before answer, plea or demurrer filed thereto. 5. An order to amend the answer of defendant before a replication is filed thereto, or the cause is set down for here. I Equity Rule 2. 2 Equity Rules 1, 2. Equity Rule 5. 4 Equity Rules 18, 34, 46. 6 Equity Rule 28. 28 Federal Equity Procedure. 27. Ein upon billy and answer. 1. An order dismissing the plaintiff's bill, upon his failure to file his replication to defendants and swear at the time, required by the rules. 2. Or upon his failure, to reply to any plea or to set down any plea or demurrer for argument at the time, required by the rules. 3. An order setting down for argument any plea or demurrer, 4. Or any exception to any answer for insufficiency. 5. Or a suggestion by defendant in his answer, that the bill is defective for want of parties. 6. But any order, rule or other proceeding granted by the clerk may be suspended or altered or rescinded by any judge of the court, upon special cause shown. 7. Upon the filing of a bill, the clerk shall, upon the application of plaintiff, issue the process of sub pama thereon, as of course, requiring the defendant to appear, and answer the exigencies of the bill. 8. And he may, in like manner, issue writs of assistance, execution, attachment, or sequestration, for the purpose of compelling obedience to any interlocutory or final order or decree of the court. 9. He may issue commissions to take testimony. 10. And he may issue sub pamas for witnesses within his district, to appear and testify before any commissioner, master, or examiner. 11. 27. Orders by the judges at chambers, and at rules in order to give flexibility to the system of interlocutory procedure for the speeding of causes to a final hearing, and to meet every exigency, and relieve equity procedure in the circuit courts of the United States from the intolerable delays, which were so long the reproach of the system of procedure in the High Court of Chancery in England. It is provided by both rule and statute that any judge of the circuit court, as well in vacation as in term time, may at chambers, or on the rule days at the clerk's office, make and direct all such interlocutory orders, rules and other proceedings, preparatory to the hearing of all causes upon their merits, in the same manner, and with the same effect as the circuit courts could make, and erect. The 1 Equity Rule 60. II Equity Rule 66. Robinson v. Satterley, 3 Soy 134, Fed. Casno. 11967. O Equity Rule 38. 4 Equity Rules 33, 38. 5 Equity Rule 63. S Equity Rule 52. 7 Equity Rule 5. O Equity Rules 7, 11, 12. 9 Equity Rules 7, 8, 9, 92. O Equity Rule 67. 11 Equity Rule 78. 27. Interlocutory Procedure 29. Same in term, reasonable notice of the application therefore being first given to the adverse party, or his solicitor, to appear, and show cause to the contrary, at the next rule day thereafter, unless some other time is assigned by the judge for the hearing. One, it would seem that, under the authority of this rule and statute, keeping constantly in view the policy and intendment of the interlocutory procedure, a judge of the circuit court has the power in vacation at chambers, and at rules in the clerk's office, to make and direct any interlocutory order, rule or other proceeding, preparatory to the hearing of any equity cause upon its merits. All that is required to authorize the order, or proceeding is, that it be preparatory to the hearing of the cause upon its merits, and reasonably adapted to that end, and not in violation of the spirit and policy of the rules. A judge may at chambers, or on a rule day at the clerk's office, make an order referring any bill, answer or other pleading to a master for impertinence or scandal, to an order allowing plaintiff to amend his bill, after answer, plea or demurrer filed thereto, and either before, or after replication filed. 3. An order sustaining, or overruling a plea or demurrer, and allowing the parties to amend, or further time to plead. 4. An order allowing defendant further time to plead, answer or demur to the original bill. 5. Or further time to file a supplemental answer, after plaintiff has filed an amendment to his bill. 6. An order upon a suggestion made by the defendant in his answer that plaintiff's bill is defective for want of parties, and set down for argument upon that objection only, within 14 days after answer filed. 1. An order allowing defendant to amend his answer after replication filed, or after the cause has been set down for hearing upon bill and answer. 8. An order appointing guardians ad litem to defend suits for infants or other persons incapable of defending for themselves. 9. A judge of the court may on any rule day grant leave to file a supplemental bill, or a bill in the nature of a supplemental bill. 10. And may, on any rule day, hear argument upon exceptions filed to an answer for insufficiency, and IUSRS, Second 638, Equity Rule 3, 2 Equity, Rules 26, 27, 3 Equity Rules 29, 45, 4 Equity Rules 33, 34, 35, 38, Equity Rule Point Lay 18, and Equity Rule 46, 7 Equity Rule 52, S Equity Rule 60, 9 Equity Rule 87, 10 Equity Rule 57, 30 Federal Equifi Procedure, 28. Make an order overruling or sustaining the same one inasmuch as the taking and stating of an account by a master is a proceeding preparatory to the hearing of the cause upon its merits, and the Supreme Court has held that references to masters should be upon interlocutory order, and has with emphasis expressed its disapproval of the practice of referring causes to a master upon final decree. It would seem that a judge is authorized to make an order at chambers, or on a rule day, referring a cause to a master, to take and state an account, or for other purposes within the scope of the duties of a master. To the judges of the circuit court have power at chambers to issue writs of northeast to each republica, but suits in equity must be first commenced, and satisfactory proof made that defendant designs quickly to depart fro in the United States. 3. And they may at chambers grant writs of injunction, and pending application for the writ may make a temporary restraining order with or without security. 28. The order book in the interlocutory procedure, which has been prescribed by the rules, preparatory to the hearing of causes upon their merits. Nothing is of greater importance, nor more worthy of attention, than the order book. It is a wise, judicious, and useful contrivance. It performs the double functions of a record of all motions, rules, orders and other proceedings made, and erected in the clerk's office in vacation, or on rule days, or at chambers, and that of the means of notice to the parties and their solicitors of the proceedings entered therein. It is a record and a notice. The rules direct that all motions, rules, orders and other proceedings made, and erected at chambers, or on rule days at the clerk's office, whether special or of course, shall be entered by the clerk in an order book, to be kept at the clerk's office, on the day when they are made and erected, which book shall be open at all office hours to the free inspection of the parties in any suit in equity and their solicitors. Every step taken in a cause should, at the time it is had and done, be entered in the order book. I Equity Rule 63, La Vega v. Lapsley, 1 Wood semicolon 428, Fed. Cass. Number 8123. 24 Gay v. Conrad, 6 How 201. AU. SRS, 2nd 717, Equity Rule. 21, SEMA v. Hazza 1D, 1 Johns. Chapter 1. 4 Equity Rule 55, USRS, Sex. 717, 718, 719. 29, 30. J. Interlocutory Procedure 31. Under the appropriate style of the case, from the filing of the bill to the setting of the cause down for final hearing 129. Same notice except in cases where personal or other notice is specially required or directed. Entry in the order book shall be deemed sufficient notice to the parties and their solicitors, without further service thereof, of all orders, rules, acts, notices and other proceedings entered in the order book, touching any and all the ANNOTATEDs and the suits to and in which they are parties and solicitors. And notice to the solicitor shall be deemed notice to the parties for whom they appear, and whom they represent, in all cases where personal notice on the parties is not otherwise specially required. Where the solicitors for all the parties in a suit reside in, or near the same town or city, the judges of the circuit court may, by rule, abridge the time for notice of rules, orders or other proceedings not requiring personal service on the parties, in their discretion. All motions for rules or orders or other proceedings, which are not grantable of course or without notice, shall, unless a different time be assigned by a judge of the court, be made on a rule day, and ed in the order book, and shall be heard at the rule day next after that on which the motion is made. And if the adverse party, or his solicitor, shall not then appear, or shall not show good cause against the same, the motion may be heard by any judge of the court en part, and granted, as if not objected to, or refused, in his discretion. A party is not charged with notice ether, filing of pleas, demurrers and other proceedings unless the same are entered in the order book too. 30. Policy and method of the interlocutory procedure. The policy and purpose of the interlocutory procedure, authorized by the equity rules to be had before the clerk in vacation and on rule days, and before the judge at chambers, are to advance causes to a speedy hearing on their merits. This policy is expressly declared by the rules and the statutory provision. It is for this purpose that the circuit courts of equity shall be deemed always open, and this intendment should be kept steadily in view in the interpretation and application of the 1 Equity Rules 2, Foregone Sent. Rye. Co. 1 Saw 63, Fed. 2 Equity Rules 4, 6, Newby v. or Cass. Number 10145. 32 Federal Equity Procedure. 31. Rules 1 As to the method, it is the intention that a cause shall be advanced at least one step on every rule day, and that special applications shall be made to the judge at chambers as often as the exigencies of causes may require, to dispose of all dilatory matters, aid the parties in perfecting the pleadings, and remove all obstructions out of the way of the speedy and orderly progress of the suit to a final hearing on its merits. In consonance with this policy and method, upon the filing of the bill the writ of subpoena is issued and made returnable, not to a term of the court, but returnable into the clerk's office the next rule day, or the next rule day but one, at the election of the plaintiff, occurring after 20 days from the time of the issuing thereof. 2. And the appearance day of the defendant shall be the rule day to which the subpoena is made returnable, provided he has been served with process 20 days before that day, otherwise his appearance shall be the next rule day succeeding the rule day, when the process is returnable, and the defendant shall on the appearance day, either personally or by bis solicitor, enter bis appearance, which shall be entered on the day thereof by the clerk in the order book 3. 31. Same. When pleadings are to be filed it is the duty of defendant, unless otherwise specially ordered by a judge of the court, to file his plea, demurrer or answer to the bill in the clerk's office on the rule day next succeeding that of entering his appearance. 4. And if defendant does not file a demurrer nor a plea, but files an answer which the plaintiff deems sufficient and free from impertinence and scandal, it is the duty of plaintiff to file the general replication to the answerer on or before the next rule day, and put the cause at issue, and make it ready for the proofs. 5 and 3 months, AI, ed no more, shall be allowed for the taking of testimony after the cause is at issue, unless the court or a judge thereof shall enlarge the time. 6 Where there is filed no demurrer nor plea, but defendant files a sufficient answer, and the plaintiff files his replication, on the rule days required by the rules, the cause. IUSRS, Second 638, Equity Rules 1, 2, 3, 4, 5, 6. 2 Equity Rule 1L3 Equity Rule 17. 4 Equity Rule 18. 5 Equity Rule 66. 6 Equity Rule 69. 32.J Interlocutory Procedure. 33. Is at issue in 2 months after the defendant enters his appearance, and, with the 3 months allowed to take testimony, only 5 months are required to prepare the cause for hearing on its merits. If defendant files a plea, it is the duty of plaintiff to reply to it, or set it down for argument upon its legal sufficiency not later than the rule day next succeeding, that upon which it is filed. 1 If plaintiff, deeming the plea a good and sufficient bar to the bill, files the general replication thereto, the cause is put at issue, and prepared for hearing upon its merits with the same speed and expedition as in the case of an answer to. If defendant files a demurrer, the plaintiff should set it down for argument by the next succeeding rule day. 3 When a demurrer has been reinterposed and set down for argument, or a plea has been set down for argument upon its legal sufficiency, the argument may be had before any judge of the court at chambers, or on a rule day, and the demurrer or plea disposed of, and leave and directions given as to further pleadings in the cause. If the plea or demurrer be overruled, defendant will be assigned to answer the bill at the next succeeding rule day, or at such other period as, consistently with justice and the rights of defendant, the same can, in the judgment of the court, be reasonably done. If the plea or demurrer be allowed, the plaintiff may be allowed to amend his bill, and a judge of the court having, upon such special applications, determined the legal questions raised, the cause is allowed to proceed at rules as before, until at issue 4. 32. Same when exceptions to pleadings for scandal and impertinence are to be filed. If, upon entering his appearance, and reading the bill, the defendant should be advised that it contains scandalous and impertinent matter, and he desires to have such matter expunged, he must take the necessary steps to have it done, before he either pleads, demurs to warrants with the bill, and, instead of filing his defense to the bill on the rule day next succeeding his appearance, he should, on that day, take and file written exceptions to the bill for scandal or impertinence, or both, as point the case may be, describing the par. I Equity Rules 33, 38. 2 Equity Rule 33. S Equity Rules 33, 38. 3. 4 USRS, Second 638, Equity Rules 1, 3, 6, 33, 34, 35, 36, 37, 38, 34, Federal Equity Procedure. 33. Particular passages which he considers scandalous or impertinent, and he should, as early as convenient, procure an order from a judge of the court, referring the bill to a master, for scandal or impertinence, or both, and procure the master to examine, and report on the exceptions on, or before the next succeeding rule day, unless the master shall certify that further time is necessary for him to complete the examination, and unless this is done, the defendant waives his right to accept to the bill for scandal and impertinence. 1 Either party may, within 1 month after the master's report is returned to the clerk's office, file exceptions thereto, and if no exceptions are filed to the report within that period, the report shall stand confirmed on the next rule day after the month has expired. If exceptions are filed to the master's report, they shall stand for hearing before the court. 2 Defendant has a right to have all scandalous and impertinent matter expunged from the bill, before filing his plea, demurrer or answer thereto, and therefore, pending exceptions for scandal and impertinence, his duty to make defense to the suit is suspended, but when the exceptions are finally disposed of the cause proceeds under the rules. 3 When an answer is filed by defendant which contains matter deemed by the plaintiff scandalous or impertinent, and he desires to have that matter expunged, he should, instead of filing a replication at the next rule day, file exceptions for scandal or impertinence, or both, which exceptions must take the same course as that pursued in case of exceptions to bills for scandal and impertinence, and unless the plaintiff files his exceptions to the answer for scandal and impertinence on the rule day next succeeding the filing of the answer, he waives his right to accept to the answer for such cause. Pending the exceptions to the answer, the further progress of the suit is suspended, but after the exceptions are disposed of, the cause proceeds under the rules for 33. Same when exceptions to answers for insufficiency are to be filed if the plaintiff shall be advised that the answer filed by defendant to his bill is insufficient, and he desires to obtain a fuller answer from the defendant, he must, on the next succeeding rule day, file in the clerk's office written except 1 Equity Rule 27. 2 Equity Rule 83. 1 Daniel 458. O Equity Rule 27. 1 Daniel 459. Equity Rule 27. 34.J Interlocutory Procedure 35. Shines thereto for insufficiency, and if defendant shall not submit to the same and file an amended answer on the next succeeding rule day, the plaintiff shall forthwith set his exceptions down for hearing on the next succeeding rule day thereafter, before a judge of the court, and shall enter, as of course, in the order book, an order for that purpose. I. If the exceptions are allowed, the defendant shall be bound to put in a full and complete answer thereto on the next succeeding rule day, and if the exceptions be overruled, the plaintiff shall file the general replication to the defendant's answer on, or before the next succeeding rule day. 2. 34. Default of parties in interlocutory procedure. The parties to suits in equity, by taking advantage of the failure of their adversaries to observe the rules, have the power to compel them to observe the interlocutory procedure to speed the cause to a hearing on the merits. If the defendant fail to answer the original bill or any amended bill, or fail to file a further answer upon the sustaining of exceptions for insufficiency, the plaintiff may take a decree pro confesso against him, as of course 3, if the plaintiff shall fail to file the general replication to the answer of defendant not accepted to, or adjudged sufficient. 4. Or shall not reply to any plea, or set down any plea or demurrer for argument. 5. By the time required by the rules, his bill shall be dismissed as of course, unless the court or a judge thereof shall allow further time. And when a bill or answer has been referred to a master for scandal or impertinence, the order of reference shall be considered as abandoned, unless the party obtaining it shall, without any unnecessary delay, secu the master to examine, and report thereon on, or before the next succeeding rule day, or the master shall certify that further time is necessary for him to -0 complete the examination. 6. And when exceptions are filed to an answer for insufficiency, and are not submitted to by the defendant, and the plaintiff fails to set them down for hearing before a judge of the court on the second rule day after they L. Equity Rules 61, 63, 64. L. Equity Rule 66. 3. Equity Rules 18, 46, 64. 4. Equity Rule 66. B. Equity Rule 38. G. Equity Rule 27. 36. Federal Equity Procedure 35, 36. Are filed, the exceptions shall be deemed abandoned, and the answer deemed sufficient. 1. 35. Interlocutory procedure upon removal, by virtue of the Procedure Act, in the courts of the United States the union of equitable and legal causes of action and grounds of defense is forbidden, and upon the removal of a cause from a state court into the United States Circuit Court, the parties have a right to insist that the provisions of this act, however variant from the procedure of the state court, shall be followed. If an action at law be removed from the state court into the United States Circuit Court, it should be placed on the law docket, and proceeded with accordingly. If a cause of equitable cognizance be removed, it must proceed as an equity cause, and if it should, by inadvertence or from any cause, be placed upon the law docket, it should, upon motion of counsel, be transferred to the equity docket, and be proceeded with under the equity rules and procedure in like manner, as if the suit had been originally commenced in the circuit court. if the pleadings, as constructed in the state court, and under the authority of state procedure, unite legal and equitable causes of action or grounds of defense, upon removal there should be an order for a repleader, and the suit should be recast into 2 suits, one at law, and one in equity, and proceeded with according to law and equity procedure, respectively. 36. Purposes of the first, second, and third chapters. The preceding sections are merely introductory to the real purpose of this work, which is to trace out and succinctly state the various and successive steps of a suit in equity, from its commencement to its conclusion. The aim and method is to present in chapters 1, 2, and 3 the general basis of administration of equitable remedies in circuit courts of the United States, together with a statement of the general features of the interlocutory procedure requisite in suits in equity, and Equity Rule 63. 21 U.S. Stat at L, Chapter 36, Seconds 2, p. 276, USRS, Seconds 913, Hurt v. Harlingsworth, 100 U.S. 100, 104, American Assen Limited, v. Eastern Kentucky Land Co., 68 Fed. R 721. Perkins v. Hendricks, 23 Fed. R 418. 36 Interlocutory Procedure 31. Then in the following chapters to present, successively and in detail, the various steps which are required in the prosecution or defense of a suit in equity, from the preparation and filing of the bill to the final decree and its execution, including proceedings in the master's office. It is hoped that the general view presented in this, and chapters 1 and 2 will aid in the development of the more minute details to be hereafter presented. To pass from the general to the particular would seem to be a natural method in the development of the science of equity procedure.